Good morning. I want to welcome members of the public to this open meeting of the U.S. Securities and Exchange Commission. Today, the Commission will consider three matters geared to enhancing the practice of auditing. Well-functioning financial markets are built on trust. Critical to such trust are disclosures. This includes the financial statements disclosures that both issuers, public companies, and broker-dealers make to the investing public. Long before there was an SEC, in 1889, the first U.S. Commissioner of Labor, Carroll D. Wright, who happened also to be a statistician, spoke to a convention of labor statistics commissioners in Hartford, Connecticut. Why do I raise this? 1889. Well, Mr. Wright warned about the erosion of trust and the abuse of numbers for personal gain. He said, quote, "Figures will not lie," end quote. But he added, quote, "Liars will figure." Well, you see, my grandfather, Ellis Tillis, an immigrant from Lithuania, he ran a corner grocery store when he got to the U.S. He's not a statistician at all. He often said something similar. He said, "Figures don't lie, but liars sure can figure." Well, having watched the run-up and the aftermath of the calamitous 1929 stock market crash, I think Congress and President Roosevelt understood the wise words of Commissioner Wright and my grandfather. In response, they worked to restore trust among the investing public by enacting the first securities laws for the federal government. And nearly 70 years later, however, the system was once again breaking down. Fraud in financial reporting, accounting eventually led to historic bankruptcies such as Enron and WorldCom. Investors, you see, needed facts and figures that they could trust, figures without the liars. Congress responded by passing something called the Sarbanes-Oxley Act of 2002. Having personally had a ringside seat advising my home state Senator Paul Sarbanes on this historic legislation, I saw how both Congressman Mike Oxley and Senator Sarbanes, across the aisle, across the different bodies of Congress, they both understood all too well the importance of figures and in guarding against false figures. Their vision led to the reforms establishing something called the Public Company Accounting Oversight Board. You'll hear it referred to today as the PCAOB, as an independent watchdog over the audits of public companies and registered broker-dealers and their auditors. You see, the Enron crisis revealed a key problem: the quality of auditing standards. And candidly, the relationships between issuers and auditors, between standard setters and auditing firms, well, they had become too clubby. Auditing standards were set by effectively what was at the time a trade association, the American Institute of Certified Public Accountants. It did a lot of good things, but this professional association was writing its own rules. Therein lies an inherent conflict. To correct the course, Congress tasked the PCAOB with setting enhanced auditing standards. Now, this is 2001, 2002. For practical purposes, Congress permitted the newly established PCAOB to carry over the existing AICPA standards and put them in place on an interim basis. That's embedded in law. The expectation was that the board, the PCAOB, would produce a more appropriate set of standards going forward. Now, it's worth noting that many of the standards, these carryover interim standards, were already decades old when the board adopted them in 2003. Many also contain inherent flaws that the board was created to solve. Since then, the AICPA itself has updated numerous standards in the private company audit space. The PCAOB, however, has not done likewise. In fact, 21 years later, 42 of these 49 so-called interim standards remained in public company audit practice when I first came in at the SEC 3 years ago. Without prejudging any one of them, adhering to 20th century standards is not a faithful effort towards instilling greater trust among today's investors. 22 years after Sarbanes-Oxley was passed, I have the honor of serving as chair of this great agency. I'm proud to support the PCAOB's proposed changes to instill greater trust among investors and issuers in our markets. I want to thank the staff at the PCAOB, the board members for their diligent work on these matters. I also want to thank the staff of the SEC and my fellow commissioners for all their work preparing to consider today's recommendations. I look forward to discussing these recommendations from the staff. Now, before I turn to Paul Munter, we're going to go through three matters. I'm just going to mention a couple of thoughts on the first topic of discussion, and this relates to something called contributory liability. I'm pleased to support the rule amendment because it would strengthen accountability for individual auditors who fail to uphold their responsibilities. You see, an accounting firm, like any organization, is made up of a collection of people, whether it's a public company, whether it's an accounting firm, whether it's the SEC. We all know this. Thus, when an accounting firm commits a violation of the public's trust, there is an accompanying question. When and how might we hold people individually responsible for their roles in that firm's violation? Well, for decades, this American Institute of Certified Public Accountants that I referenced earlier has maintained a code of professional conduct. To this day, it is an ethics violation when an accountant engages in what's, quote, an act discreditable to the profession. And this includes making or permitting misstatements on an entity's financial statements by virtue of the individual accountant's negligence. That's the AICPA. Congress also addressed the question of individual professional misconduct when they set up, through the Sarbanes-Oxley Act, the PCAOB, and they authorized the board to impose an array of sanctions, not only on the registered accounting firms, but also on the associated persons who commit securities law violations or engage in misconduct. In 2005, the PCAOB adopted an ethics rule establishing some standards with regard to this, and when associated persons are liable when they take or admit to take actions knowing or recklessly not knowing the act or omission. Now, that's a lot of important legal words, but in essence, they address this. But on the other hand, when registered firms committed a violation, they're potentially liable when they do so negligently. So there is an inconsistency. Under federal securities laws, the SEC has enforcement authority with respect to any person that is or was or would be the cause of another primary violation. Again, we took this up also, well, Congress really took it up, the SEC's enforcement authority about these violations. The SEC standard relating to this cause is negligent based. Why do I go into those details? And I know Paul and his team will go in further. This all leads to an inconsistency with regard to the standard of liability. First, there's an inconsistency currently within the PCAOB's own standards regarding audit firms versus the people that work there. Second, there's an inconsistency regarding individual liability between what the PCAOB has for individuals and the AICPA's long-standing code of professional conduct. And further, as I mentioned, there's an inconsistency with SEC negligence-based approach. That's why I am supportive of these changes. And by updating the ethics rules today, I think that it will encourage accounting professionals to be more deliberative, more careful in fulfilling their duties. I'm going to turn this over to Paul now, but also I want to thank his whole team, the Office of the Chief Accountant, the Office of the General Counsel, the Division of Economic and Risk Analysis, and many other divisions each have weighed in. But with that, I think it's over to you, Mr. Munter.
Good morning, Chair Gensler. Good morning, Commissioners. The Office of the Chief Accountant recommends that the Commission approve an amendment to PCOB Rule 3502, which is an ethics rule that governs the liability of associated persons who directly and substantially contribute to a registered firm's violations of the laws, rules, and professional standards that the PCOB is entrusted with enforcing in public company and broker-dealer audits. The PCOB's mission is to protect the interests of investors and to further the public interest in the preparation of informative, accurate, and independent audit reports. Congress mandated that the PCOB establish fair procedures for investigating and disciplining registered public accounting firms and their associated persons. Consistent with its authority in the Sarbanes-Oxley Act, the PCOB can impose certain sanctions for violations committed negligently, which is defined as a failure to exercise reasonable care by either registered public accounting firms or their associated persons. Sarbanes-Oxley gives the PCOB authority to impose sanctions for a single act of negligent conduct that constitutes a violation, and to impose certain enhanced sanctions if a registered firm or an associated person has engaged in repeated instances of negligent conduct. However, the PCOB's current rule on contributory liability does not fully align with its statutory enforcement authority, as Chair Gensler noted. That is, because the PCOB's current rule 3502 requires a showing of at least recklessness, which is a harder standard to establish when it comes to imposing sanctions for contributory liability on associated persons who directly and substantially contribute to a firm's negligence-based violation. In other words, in those circumstances, the PCOB currently has to show that the associated person was not just acting unreasonably, but made an extreme departure from the standard of ordinary care. Therefore, today we recommend that the Commission approve an amendment to Rule 3502 that fixes that misalignment and also aligns the PCOB rules with our own rules. As the Chair mentioned, many members of the Commission staff contributed to this process in preparing for this recommendation, as well as the other two matters that we will discuss later this morning. In the interest of time, I'll save my thanks to the final statement of the day, and I will now hand over to Mike Hoy-Winton to present an overview of the amendment.
Thank you, Paul, and good morning, Chair Gensler and Commissioners. I'd like to expand on the recommendation before the Commission to approve an amendment to PCAOB Rule 3502 and explain the staff's reasoning. As previously mentioned, Rule 3502 is a PCAOB ethics rule that governs the liability of associated persons who directly and substantially contribute to a PCAOB registered firm's violations of the laws, rules, and standards that Congress authorized the Board to enforce. Under Rule 3502's current formulation, the Board cannot impose sanctions on associated persons who directly and substantially contribute to a firm's violations through negligent conduct. Because PCAOB registered accounting firms act through natural persons, their associated persons, it follows that when a registered firm is found to have committed a negligence-based violation, such negligence is due to the negligent contributions of its associated persons. Rule 3502, however, currently requires the Board to demonstrate that an associated person behaved at least recklessly before the Board can institute enforcement proceedings against such persons for contributing directly and substantially to a firm's negligence-based violations. Thus, under current Rule 3502, associated persons who fail to exercise reasonable care and thereby directly and substantially contribute to a firm's actionable violations may escape liability and accountability from the Board, even while the firm committing the violation does not. Last September, the Board proposed amending Rule 3502. In response, the PCAOB received approximately 27 comment letters from an array of stakeholders asserting a variety of views, all of which are discussed and addressed in the PCAOB's adopting release. On June 12th, PCAOB voted unanimously to adopt the amendment, and the Commission published a related notice to solicit comments. We received 2 comments in response to our notice, both of which have also been considered by Commission staff. Changing the liability standard for contributory conduct for associated persons to a minimum showing of negligence would promote investor protection by making Ethics Rule 3502 a more effective deterrent for auditor misconduct. The amendment would do this by encouraging auditors to act with the reasonable care that, under other applicable standards, such auditors should already be deploying in their PCAOB audit engagements. Holding associated persons accountable in PCAOB enforcement proceedings only when they have engaged in a reckless or extreme departure from reasonable care is out of step with other applicable professional standards. Additionally, the change to a minimum negligence showing would align the Rule 3502 with the authority that Congress provided to the board. When Congress enacted Sarbanes-Oxley, it provided the PCAOB with the ability to impose certain sanctions for negligent conduct, including single instances of negligence. By no longer requiring a showing of at least recklessness to hold associated persons liable for contributing to a firm's negligence-based violation, the recommended amendment would better align Ethics Rule 3502 with the board's grant of statutory authority. Two related points are worth emphasizing. First, in commission enforcement proceedings, associated persons are already subject to potential liability, including monetary penalties for negligently contributing to a registered firm's violations of the various laws and rules governing the preparation and issuance of audit reports to the Commission. Thus, the recommended amendment would not subject auditors to a different liability standard because the Commission already has such authority. Second, the amendment retains the directly and substantially modifier in the current rule to describe the connection between a contributory actor's conduct and a registered firm's primary violation. For conduct to directly contribute to a primary violation, it must either constitute the violation or be a reasonably proximate facilitating event for the violation. And for conduct to substantially contribute to a primary violation, it must contribute to the violation in a significant way. Thus, the amended Rule 3502 would not reach an associated person's conduct that, while contributing to the violation in some way, is remote from or tangential to the firm's violation. The Sarbanes-Oxley Act provides that any additional rules adopted by the PCAOB do not apply to audits of emerging growth companies or EGCs, unless the Commission determines that the application of such additional requirements is necessary or appropriate in the public interest, after considering the protection of investors and whether the action will promote efficiency, competition, and capital formation. We believe that applying the amendment to the audits of EGCs is indeed necessary or appropriate in the public interest. By applying the amendment to all associated persons of registered public accounting firms engaged in the audits of issuers and registered broker-dealers, including audits of EGCs, investors will benefit from higher standards of audit quality and enhancements to investor protection brought about by the amendment. As discussed more fully in the draft order, we have reviewed and considered the amendment, the information submitted by the PCAOB, and the comment letters received. Based on that review and as stated by Paul in his remarks, we recommend approval because the amendment is consistent with the requirements of Title I of the Sarbanes-Oxley Act and is necessary and appropriate in the public interest or for the protection of investors. Also, as I discussed earlier, we recommend applying the amendment to audits of EGCs. If approved, the amendment to Ethics Rule 3502 would become effective 60 days from the date of Commission approval and would apply to conduct occurring after the effective date. The amendment would not apply to conduct before the effective date. And with that, I'll turn it back to you, Chair Gensler.
Thank you so much. And with that, we'll take Commissioner's statements and questions. Commissioner Peirce.
Thank you, Chair Gensler, and thank you, Nguyen and Paul. The auditor's calling is fundamental to the health of the capital markets. For this reason, we want to ensure that the standards and rules governing auditors are clear and sensible, do not rob auditors of their confidence to exercise judgment, and that they facilitate auditors' focus on the critical job of ensuring that financial statements are reliable. The Commission's review of the PCAOB's rules and standards is integral to the process that Congress established to ensure the quality and effectiveness of the PCAOB's work. Commission review of PCAOB standard setting is particularly important now. First, as evidenced by high audit deficiency rates and much enforcement saber rattling, the PCAOB appears to be struggling with its critical mission of fostering audit quality. Second, the PCAOB is rushing new standards out the door without due regard for internal deliberation, public input, economic analysis, or implementation issues. Third, as many at the PCAOB and outside have noted, the audit profession faces challenges including high rates of concentration, low rates of new recruits, and exits by seasoned auditors. While many factors contribute to these challenges, deliberate and prudent regulatory steps can mitigate them, while hasty and ill-considered steps will exacerbate them. Thank you to Chair Williams, board members Ho, Stein, Thompson, and Bodick, the PCAOB staff and SEC staff, including staff in the Office of Chief Accountant, the Division of Economic and Risk Analysis, and the Office of General Counsel. Your passion for high-quality audits, which are so important to our capital markets, is evident in the work that you do. So turning to the contributory liability proposal that's before us now, I can't support this proposed change. I don't think it's either consistent with the requirements of the securities laws or necessary or appropriate in the public interest or for the protection of investors. It could have the unintended consequence of lowering audit quality and could worsen the trend toward fewer talented individuals entering the audit profession. The more expansive liability standard reverses, without any clear reason for doing so other than because we can, the 20-year-old PCAOB decision not to adopt a negligence standard. This decision reflects the PCAOB's recent emphasis on aggressive enforcement. When placed in that context, the refusal to limit application of the new contributory negligence rule to multiple instances of negligent conduct is concerning. When paired with the PCAOB's stated plan to, quote, aggressively pursue all statutory legal theories for charging respondents, end quote, assurances that it, quote, intends to deploy its prosecutorial discretion responsibly, provide little comfort. The PCAOB, of course, should enforce its rules, but bringing formal enforcement actions should not be the first tool a regulator grabs when deficiencies are identified, particularly when the conduct at issue is merely negligent. As many commenters on the PCAOB's proposal pointed out, this change is unnecessary and could have adverse consequences on audit quality. The PCAOB already can and does pursue individual misconduct under existing rules. The SEC, state accountancy boards, and audit firms already can respond to individuals' negligent contributory conduct. The PCAOB interacts routinely with the SEC's Office of Chief Accountant and staff from the Division of Enforcement and can refer any instances of negligent misconduct to the SEC. The PCAOB's own economic analysis estimates that this change will yield only 2 or 3 additional cases for the PCAOB each year. The benefits, therefore, are likely limited, but the costs are likely to be high because audit professionals could be overcome by risk aversion as they fear being second-guessed by a PCAOB enforcement regime armed with the clarity found only in hindsight analysis. It adds yet one more reason for people to leave or never join the audit profession or to refuse to take on roles in important areas like quality control. The lower liability standard may be particularly challenging for small and foreign firms. The PCAOB acknowledges that, quote, the amendment could lead some firms to exit the issuer audit market. But rather than seriously grapple with the potential costs, the PCAOB instead looks forward to a, quote, landscape characterized by a higher concentration of more capable and compliant audit firms as an outcome that mitigates the negative impacts on the competitive landscape. The PCAOB should work with audit firms to improve quality rather than seek to clear the landscape of all but the biggest firms. I do have some questions. Several commenters question the PCAOB's authority to adopt this amendment. The Commission's order affirms the PCAOB's authority under Sections 103 and 105 of the Sarbanes-Oxley Act. The PCAOB also cites another provision as authority, the Sarbanes-Oxley directive that the rules of the board shall provide for the operation and administration of the board, the exercise of its authority, and the performance of its responsibilities under this act. That provision seems inapt, and if used as an authority for a rule like this one, potentially eviscerates any limits on the PCAOB's authority. What are the limits to the PCAOB's authority under Section 101G of Sarbanes-Oxley?
Thank you, Commissioner. This is Megan Barbero. I can take that question. You're correct that PCAOB did cite Section 101G of SOX as an additional source of authority for the amendment, but I think it's worth stressing here that the board principally relied on Sections 103 and 105 of SOX, which clearly provide the board with the legal authority to amend Rule 3502. And as you noted in the draft order notes, Section 103 grants the board authority to establish, among other things, ethics standards for the audit profession. And section 105C 4 to 5 grants the board authority to impose disciplinary or remedial sanctions, including for negligent conduct. So while I recognize that the board cited section 101G as an additional source of authority, there's really no question here that the authority in 103 and 105 provides the board with all the authority it needs to promulgate this rule.
So I understand that the commission's position with respect to 103 and 105, but the 101G really puzzled me, that addition of that source of authority, as you point out, unnecessary to cite it. So if it's not necessary, then what's the purpose of having it in there? It seems to me it's taking a very aggressive reading of 101G, and so just that's the source of my question of, if they read it that way, is there any limit to what they can do under 101G?
I understand the question. I'm looking at, this is on page 36 of the board's release, and they say section 101G1 is yet another source of authority for the amendment. That's after discussing sections 103 and 105. And they cite the provision. I think it can serve as an additional source of authority, but here, of course, we have 103 and 105. So I don't read this as testing the limits of standalone authority under 101G, for example.
Well, I guess I'd like to talk to you a little bit further offline about what the limits of 101G are, because I certainly don't understand how it's relevant here. But let me move on. And I don't know if this is a question for you or for someone in OCA, but how will this new negligence-based liability standard interact with what one commenter described as the PCAOB's shift away from principles-based and toward rules-based standard setting?
I'll defer to OCA on that. Thank you.
Yeah, thank you for that question, Commissioner. I guess I struggle a little bit with the commenter's characterization of the PCAOB's shift away from principle-based standard setting. The other matters that we have before us are clearly principles-based standards. Certainly, the PCAOB looks for circumstances where additional guidance might be helpful to practice in applying the existing standards, but the PCAOB's approach to standard setting is grounded in a principles-based approach.
Yeah, I mean, I think if you look at something like some of the proposals that are out there, either that the PCAOB has out for comment or that we have out for comment, do strike me as a little bit less principles based and more rules based. So I do understand where the commenter is coming from, and I think that a misapplication of this new lower liability standard could really be quite chilling in light of those changes toward a more rules based approach. The PCAOB acknowledged that this rule and the quality control standard that the PCAOB recently finalized could overlap to cover the same conduct in some circumstances, and explained the value of the potential to be held individually liable for contributory negligence, which may increase the amount of care and attention dedicated to QC by responsible individuals. Are you concerned that this change in the liability standard could cause some people to avoid taking on quality control roles, particularly with a new and unfamiliar quality control standard potentially coming into effect?
Well, as McCoy described, the negligent conduct is predicated in the individual being directly and substantially involved in the violation. When you're looking at individuals who are part of the quality control system, that is the process by which the firm oversees its entire audit practice. Now, certainly there have been instances in the past, in fact, where the commission has sanctioned people in national office of large firms in particular matters, but that is a fairly unusual circumstance, and those who are acting in a reasonable fashion in the conduct of their duties are not directly and substantially contributing to violations, Commissioner.
Well, that gives me some comfort, but I will say the language in the release does suggest that they are intending to use this lower standard as a way to amp up their quality control standard. So I think it bears monitoring. The PCAOB insists that it's not planning to use its standard to go after junior auditors, but one of the arguments in favor of the rule change is that the market-driven consequences relating to the auditor reporting model and identification of auditors on Form AP are felt primarily, if not exclusively, by the engagement partner on an audit, while Rule 3502 applies more broadly. So are you concerned that this rule could dissuade people from entering the audit profession at all because they'll fear that an early career misstep will trigger a PCAOB enforcement action?
Well, Commissioner, again, that gets back to the grounding of the rule, which is that the associated person has to be directly and substantially the cause of the violation. If you look at the composition of audit engagement teams, it is the engagement partner that has ultimate responsibility for the conduct of the engagement, for supervision of the other members of the engagement team, and the conclusions reached by the engagement team and ultimately the firm. So without speculating on a particular hypothetical, I think it would be a fairly unusual circumstance where the less experienced members of the engagement team would be in a position where they would be directly and substantially the cause of a violation.
Okay, again, that gives me some comfort, but I think it bears watching again because the language in the release suggests that the PCAOB may be intending to use this new standard more broadly and more aggressively. After this change takes effect, do you anticipate that there are going to be self-protective behaviors that associated persons engage in to avoid being charged with contributory negligence? And how might such self-protective conduct undermine the collaborative nature and efficiency of audits?
I think in reality, the incentives are just the opposite, Commissioner. And again, this is not designed to go after exercise of judgment in the normal circumstances. It is addressing unreasonable conduct. Granted, to your point that when matters are evaluated, they're going to be evaluated after the fact. And so I think that underscores the need to have contemporaneous documentation that auditors are demonstrating what the fact pattern was as it was known at the time, how it was they came to a conclusion that that was the fact pattern, what the judgments were, and what the basis for the judgments were at the time based on the fact pattern in play. And to your point about collaborative nature, I think that the more you have engaged with others, whether it is on the engagement team or you've consulted with others within the firm beyond the engagement team, I think that goes to demonstrate the process by which an auditor is acting in a responsible fashion. So I think the incentives, in fact, are to drive more collaboration within the engagement team and within the firm.
Well, again, I hope that kind of result, it does happen, that there's more collaboration and that the documentation is good. But I think being judged through hindsight is always going to scare people into self-protective behavior, especially if this is perceived to be part of a bigger and more aggressive enforcement push. The PCAOB explained that, quote, an increase in the number of regulators on alert for the same or similar violative conduct increases the likelihood of that conduct being detected and consequently the likelihood that the conduct would be sanctioned. Although it doesn't currently, under its current rules, have the ability to bring negligence-based contributory liability charges against individuals, the PCAOB should be on the lookout already for such conduct because they can make referrals to the SEC. So how frequently has the PCAOB over the past 2 decades referred negligence-based misconduct by individuals to the SEC? And in how many of those instances has the SEC declined to bring a negligence-based secondary liability charge?
Thank you for the question, Commissioner Peirce. It's Natasha Guinan. I'll handle this answer. So really a two-part answer. First, after conferring with colleagues in our own enforcement division and in the General Counsel's office, I can't actually provide you with the number during this meeting because it's non-public information, but I can describe for you in greater detail exactly how PCAOB referrals work to our enforcement division, if that would be helpful to you.
I don't know that that's necessary. I think that the point is that they certainly can make referrals to us, correct?
Yes, but typically, like other third parties that make referrals to us, Commissioner Peirce, they refer conduct, facts, factual allegations that they've uncovered, as opposed to causes of action or charging theories such as negligence. So in the normal course, when we receive a referral from the PCAOB, which we do quite frequently in our regular touch points and pursuant to the board rules, which require them to report conduct that they're chasing down, it consists of an evidentiary record that our staff then looks into. They may investigate. Critically, because the SEC has different sets of enforcement tools from the PCAOB, our assessment of whether those particular factual or conduct-based allegations warrant staff recommendation of a violation theory to the commission are slightly different. So among other things, just to state the obvious, the commission has an additional forum in which it can pursue enforcement proceedings. We also have a general enforcement authority pursuant to which the SEC issues subpoenas, not only on associated persons who are the subject of the current PCAOB amended rule, but also on third parties. And the SEC staff, when they receive these referrals from the PCAOB and from other third parties, we often, in an audit context, have the ability to assess and gauge the alleged conduct against the backdrop of the issuer-related conduct or the broker-dealer-related conduct, which is another thing that the PCAOB lacks legal authority to look into. So the bottom line is whether any particular board referral, which again is typically tied to conduct, results in a recommended SEC enforcement action depends on many, many circumstances. And I understand that our own enforcement division, among other things, takes into consideration unnecessary duplication of efforts and our own staff resources.
Okay, thank you. I mean, I think again, this illustrates that PCAOB has a way forward if they notice conduct by an associated person that they think warrants enforcement action. As one commenter noted, when the SEC brings negligence-based cases, it typically also brings a case under Rule 102E of the SEC's Rules of Practice. And for that rule to apply, there must be either repeated instances of unreasonable conduct or a single instance of highly unreasonable conduct, which means higher than ordinary negligence, but lower than the traditional definition of recklessness. Will the PCAOB be bringing cases that the SEC would not, since the SEC in practice hasn't pursued instances of simple negligence?
I think the short answer to that, Commissioner, is it's very hard to speculate on what future fact patterns there might be and whether either the PCAOB or we would pursue without knowing more specifically what the fact pattern is.
Okay, fair enough. I appreciate that the PCAOB's assurances that it doesn't intend to use this new liability standard to sanction isolated good faith errors in professional judgment give us a little comfort. But how do we ensure that the PCAOB does not use this lower standard to look through the unforgiving lens of hindsight to punish a well-intentioned auditor for her work on a highly complex, and as we discussed before, collaborative audit engagement that entail judgments about which reasonable minds can disagree?
Yeah, I think that gets back to the core point we were touching on a moment ago, Commissioner, that it is incumbent upon an auditor to make sure that it has contemporaneous and robust documentation that demonstrates an understanding of the fact pattern and provides a basis for the judgments that were made at that point in time. And therefore, when matters being looked at, as you rightly note, after the fact, there is a demonstrated documentary trail that supports the auditor's assertion that the judgments made were reasonable in light of the facts that were known at the time.
Well, I think that one of the problems this illustrates is that you can end up with a situation where a firm in the course of an inspection is talking with inspectors and may agree that, to some language in the inspection report, it may not be worth the firm fighting that. And then it could be difficult later for the individual involved to say, hey, that was a reasonable exercise of judgment when the firm has already sort of come to a different conclusion. So I think this can lead to some really difficult actual circumstances. And I hope that we, in our role, will be closely watching how the PCAOB uses this new authority. Thank you. I don't have any additional questions.
Thank you, Commissioner Purst. Commissioner Crenshaw.
Good morning. I'm happy to be here today to discuss 3 important rules coming out of the Public Company Accounting Oversight Board, or as you've heard, the PCAOB. The work of auditors is crucial to investor confidence in the market. Auditors are essentially external accountants that provide the public with assurance that a company's financial statements and the controls that produce those statements are reliable. They exercise due professional care, skepticism, and are subject to independence requirements to mitigate conflicts of interest, conflicts that exist by virtue of clients paying them to conduct audits. Because the work of auditors is such an important cornerstone of market confidence and integrity, it's equally important that we have in place a meaningful system of rules and regulations for the audit profession. Without such rules, the accuracy and reliability of financial statements would disintegrate, eroding with it investor trust in our entire market. The PCAOB, with its specialized expertise, independently oversees that system of rules, and in so doing, also provides a crucial market function. Today, the Commission will vote, as you've heard, on 3 matters. In reaching this stage in each matter, the PCAOB has engaged stakeholders and its investor advisory groups, issued proposing and adopting releases, held an open comment period, reviewed and incorporate comments received, and explained thoroughly the rationales for these actions. As part of our statutory oversight function, the SEC staff have reviewed each of these matters, held an additional comment period, and provided us with their recommendations following in-depth consideration of comments submitted. These rules and standards are the product of a strong and robust process, and I'm thankful to the staff at the SEC and the PCAOB for their hard work and dedication, and to the members of the public who have provided their input. The end result benefits from this iterative process and this engagement. Now, the first of the 3 matters on the agenda today, as you've heard, concerns the PCAOB's amendments to its contributory liability rule. The PCAOB proposed and then adopted an amendment to its rules governing an individual auditor's ethical obligations to act in accordance with laws, rules, and standards, and to not contribute to violations of those requirements when conducting an audit under PCAOB standards. The amendment aligns the standard of accountability for an individual auditor with the standard applied to audit firms. Currently, the relevant rule requires a showing of recklessness for an individual to be held liable for a registered firm's negligent conduct. Recklessness requires a showing an extreme departure from the standard of ordinary care. However, as we all know, an audit firm does not act unless the people within it do so. Therefore, the current formulation means that even though a person's action could contribute, even in large part, to a firm's negligent conduct, that individual would not necessarily be held liable or subject to sanction because of the application of this higher standard. The matter before us resolves this incongruity and is informed by years of PCAOB investigation and enforcement experience. Today's rule also eliminates an incongruity in authority. The SEC currently has the ability to bring actions against and seek remedial relief and penalties from individuals associated with audit firms who have acted negligently, while the PCAOB currently does not. The difference in the SEC's authority and the PCAOB's authority is also resolved by the passage of today's new rule. In closing, I want to echo a point made by several of the board members and Chair Williams. The amendments do not provide regulators with the ability to play gotcha or to supplant the reasonable, if mistaken, judgment of the auditor. Rather, by employing a negligent standard, the PCAOB will be required to make a showing that an individual did not exercise reasonable care. An auditor would have to act unreasonably and then also directly and substantially contribute to the firm's violation in order to be held liable under these standards. Junior professionals or other auditors who are executing their responsibilities in good faith and with due care would not incur liability under this amended rule, and the PCAOB underscored this in its adopting release. I want to thank all of those who worked on the rule. The process and the rules and standards that result from it represents thousands of hours worked, a tireless effort of many dedicated public servants. So thank you to the Office of the Chief Accountant, the members of the PCAO board and its staff, and the members of the public who participated in this process. Appreciate it, and I support today's rule. Thank you.
Thank you, Commissioner Crenshaw. Commissioner Ueda.
Thank you, Chair Gensler. Today, the Commission considers whether to approve two standards and one rule that have been adopted by the PCAOB. Before discussing the first item on amendments to the contributory liability rule, I wanted to share some general thoughts about the Commission's oversight of rulemaking by the PCAOB. In the Sarbanes-Oxley Act of 2002, Congress vested the Commission with this oversight responsibility when it created the PCAOB. It is a responsibility that the Commission should not take lightly. But in carrying out such oversight, the Commission must also recognize that the board was created by Congress as a separate organization. In that respect, the PCAOB should not operate as a subordinate reporting unit to the Commission's Office of the Chief Accountant or to the individual Commission chairman. The PCAOB reports to the Commission, not the Commission staff. While I appreciate the regular and constructive engagement between the PCAOB staff and the Commission staff, and indeed, I'm very appreciative of the regular conversations that I have with Board Chair Erica Williams and each of the PCAOB board members throughout the year, we cannot lose sight of the congressional directive that the PCAOB operates under the oversight of the Commission as a whole. Thus, I'm disappointed that the PCAOB is not part of today's meeting. The core function of oversight, in my view, is to ask, what are you doing and why? And there's nobody from the PCAOB to answer these or other questions from me or my fellow commissioners. I do not view this approach as an effective method for the Commission to carry out its oversight function, even if it is legally permissible. I fail to understand why the persons with the most technical expertise and who are most central to today's decisions are not at the discussion table, or in this case, a virtual discussion table. Now, I've been told that having someone from the PCAOB speak at today's meeting may raise procedural issues. However, we have specific rules. In fact, the Commission's rules specific governing consideration of PCAOB rules specifically authorize the Commission to call for oral presentations if they would facilitate consideration of relevant issues. And at least for me personally, I would have found that helpful today. Unfortunately, the Commission has not chosen to exercise this authority. I hope that the Commission revisits this approach for future rules from the PCAOB. I think it would lead to better consideration of matters before us. In deciding whether to approve a PCAOB rulemaking, I consider factors similar to those when I evaluate a Commission rulemaking. These include: 1, has the final rule or standard identified a problem that it is trying to solve? Is there data to show that the problem exists or is the PCAOB regulating by hypothesis? 2, does the final rule or standard represent a logical outgrowth of the proposal? Have the concepts in the rule or standard been adequately exposed for market participants to evaluate and comment? 3, has the board adequately evaluated and quantified to the extent possible the costs of the rule or standard? Costs can be both financial and non-financial and can be borne by the auditing profession, audit firms, companies and broker-dealers subject to the audit, and most importantly, investors. 4, related to costs, has the PCAOB considered the aggregate impact of its rules and standards that will become effective at or around the same time? Or has it adopted tunnel vision to focus only on the particular rule or standard? I've been involved in rulemaking for over 20 years, both federal and state levels. Consideration of these factors and thoughtful responses to them are the hallmark of a high-quality rulemaking process. Turning to the first item, amendments to the board's contributory liability rule. Holding persons responsible is an important goal of any regulatory regime. Audit firms violate PCAOB standards when they operate in a negligent manner. However, while audit firms may be responsible for acting negligently, audit firms operate through individuals. What should their responsibility be towards ensuring that the audit firm does not act negligently? Lowering the standard of conduct for individuals from recklessness to negligence would reverse the board's 2005 decision to establish a recklessness standard for contributory liability. Audits have become more complex since 2005. While the PCAOB should have the tools to hold persons accountable, would lowering the standard of conduct for liability do more harm than good to the auditing profession? As some commenters noted, a negligence standard could discourage auditors from taking on more advanced audit roles, have a chilling effect on collaboration among auditors within the same firm, and hinder efforts to reverse the decline in new accountants. However, a negligence standard would be consistent with the standard of conduct that the Commission needs to prove for its cease and desist proceedings against associated persons or contributing to a firm's violations of the Commission's reporting requirements. Furthermore, a negligence standard would create a parallel standard for liability under the board's rules. Currently, a firm can commit a primary violation of a standard by acting negligently, but an associated person's secondary liability for that violation is based on a recklessness standard. Whether a liability rule strikes the right balance for being prophylactic and having no bite will depend on how it's enforced. The PCAOB's adopting release states that the board, quote, does not anticipate that the rule change will be used to sanction isolated good faith errors in professional judgment, let alone be wielded as a blunt or draconian instrument, including with respect to less senior engagement team members, unquote. I hope that the board and its staff acts in accordance with that intent in the future. Now, I want to thank the PCAOB's members and the staff and the Commission staff for their work on this, especially from the Office of the Chief Accountant and the General Counsel. I have some questions based on some of the presentations here and comments made by Chair Gensler, Mr. Munter, and the staff here. Particularly, I want to focus on what you said, Mr. Munter. You said this proposal fixes that misalignment, and that's a direct quote from what you said. Now, are you suggesting that the PCAOB acted negligently or was procedurally flawed when they adopted the original standard back in 2005?
Thank you, Commissioner. Number one, when the PCAOB adopted the standard back in 2005, it obviously was a very new organization, and it went through, of course, notice and comment in that proposal and ultimate adoption process. The PCAOB now has the benefit of 18 years of experience of dealing with its existing rules, and has certainly seen a number of fact patterns that have helped inform the board about why it should address the proposal we have before us today.
I mean, that's certainly how it was explained to me leading up to this meeting. And I'm one who has been a proponent of retrospective review. How are things working out? And I understand that there are certain efficiencies. There is a familiarity with the facts at issue. And in essence, if there are individuals who have negligently contributed to an audit firm's violations or other failures, they can proceed against the audit firm, but at the end of the day, it's other people, in essence, when penalties are assessed against the audit firm paying that, whereas the individuals actually responsible may go free, so to speak, without taking any sort of accountability or responsibility for those errors and omissions, unless the commission steps in and takes action. And there is then, as I think was just previously described, that means getting a whole new enforcement team up to speed on a case that has already been investigated. But I did say I am bothered by this fixes. It suggests it's wrong. So I appreciate your clarification on that, because I don't think that's the right way to characterize it. I think as we've now had 20 plus years of practice and seeing whether this works, there are ways to be gained in regulatory efficiency on this. I don't think it's right to characterize what Chairman Olson did, what former board members like Steve Harris is suggesting, that somehow they did something that was incompetent, or that they were acted, in the worst case scenario, they were somehow unduly influenced by lobbying that caused them to change their original proposal from a negligent standard to a recklessness standard. That's not what you're insinuating. Am I correct?
That's correct, Commissioner.
All right. Now the PCAOB in their adopting release said that that they would not be enforcing it. That they saw a difference between errors in judgment versus unreasonable conduct. Or am I mistaken on that? But I thought that's what they put in their own adopting release.
That's correct, Commissioner. The standard of negligence is unreasonable conduct. Errors in judgment that are supported by reasonable conduct do not give rise to a negligence assertion.
Okay, can you give me some examples of just where that might occur? Someone might make an error in judgment, but it might not amount to unreasonable conduct.
Well, without having a specific fact pattern at hand, it's hard to be specific, but what happens in the conduct of an audit is the audit professionals are going to have to make professional judgments on a number of different matters. And to the extent that they have approached that exercise of judgment in a thoughtful manner, which means investigating and making sure they have an understanding of the fact pattern as it exists or as it is known at that point in time, a demonstration of the alternatives that were considered and why a particular alternative was reached and others were rejected. And again, as I mentioned earlier, contemporaneous documentation of that thought process, even if with the benefit of hindsight, a different judgment might have been appropriate, to the extent that that process is demonstrated contemporaneously, that would generally support a reasonable exercise of professional judgment.
Okay, I mean, what you just described to me sounds like, quite a bit of work. And if somebody does all that work and they still make a bad judgment, I think, that's one of the concerns is, does that leave them still open? Well, how could you make this decision based on this work? That's unreasonable conduct. I mean, I guess what I was thinking more is sometimes at the outset, scoping, and as you do your procedures and you try and figure out how deep you're going to go, you may make a judgment. Should we go further? Should we not go further? You can always do more work in an audit, of course, but the whole purpose of the audit is not to revisit every single transaction, make sure they're recorded, but it's to sample and go through procedures where you can develop enough to be able to express an opinion. And at least some of the judgments seem to be how far you go. Would that be something that might, in retrospect, hey, you could have gone further, but what you did, and perhaps it was an error in judgment, but that was not unreasonable under the circumstances?
Yeah, again, without speaking to a specific fact pattern, as you rightly say, there's always additional procedures that could be performed in a specific engagement, but it is the responsibility of ultimately the engagement partner to reach a judgment as to whether or not the audit team has obtained sufficient appropriate audit evidence to support the opinion that is going to be expressed.
So with respect to this, I think there are certain times you're going to have audit failures. If you have an audit failure, does that automatically mean that people were negligent, or is it possible everyone could have acted reasonably and you can still end up having a potential audit failure?
Well, I think that depends on how you define an audit failure, Commissioner. So without knowing your definition, it's hard for me to answer that. Okay,
well, let's just say that something requires a restatement. Or do you think that, under this, basically, if a restatement's required, then by definition, somebody has acted, people have acted unreasonably?
It's very difficult to generalize, Commissioner, without a specific fact pattern.
Well, I'm just asking, is it at all possible, or is it not, in your view?
Again, without a specific fact pattern, Commissioner, I don't really know that I can generalize.
Okay, so well, I don't exactly know what you're saying. I'm really just asking, is it ever possible for someone to have, and you're saying that you cannot give a response, which I'm going to take as you're suggesting that no, if there ever is a restatement, then it seems like the fact that there had to be unreasonable conduct, that makes me concerned about the standards. I don't have any further questions.
Thank you, Commissioner Ureta. Commissioner Lizarga.
Thank you, Chair Gensler, and thanks to the staff of the Commission for the presentations, and to the staff of the PCAOB and the Commission for all of their extensive work on these standards. Chair Gensler, you alluded to some of the history on the Sarbanes-Oxley Act that I'd like to revisit as well, given that I also was there for the creation of the Sarbanes-Oxley Act when I was a committee staffer at the time. And look, that history is, I think, important to restate here because Congress enacted the law, the act, against the backdrop of a series of major accounting scandals and accounting frauds. And they rocked our markets. They shattered public confidence in the integrity of financial reporting. And I think it's telling that both chambers of Congress passed the final version of the legislation nearly unanimously. And the act established the board, and the board now has the independent responsibility of overseeing public accounting firms and setting auditing standards, strengthen auditor independence, corporate accountability, enhance financial disclosures, and it made it possible for investors to recoup any losses from securities law violations. So I think the law has played a vital role in ensuring that investors have access to quality financial reporting based on audit opinions that fully comply with applicable audit standards. And overall, you mentioned trust. Market confidence is tied to the presumption that audits of public companies are the product of a process that meets the high standards required by law. And a public accounting company that's registered with the board that audits the books of a public company is perceived as credible and reliable because it is subject to rigorous oversight. So in making investment decisions, investors rely on the audited financial statements of public companies, disclosed to the public and filed with the Commission. A clean audit opinion carries weight because it is a product of a rigorous process that's designed to protect investors. So this framework, I think, has served the public well. It continues to serve the public well, and we play our role in overseeing the board, also independently with our own judgment. So I think that process continues to work well. And but let me now turn my comments to the auditing standard that we're one of the first auditing standard that we're taking up here. Nearly 2 decades ago, the board adopted an auditing standard as part of a package of proposed ethics and independence rules, setting out the liability of persons associated with registered public accounting firms. Under this standard, a registered firm can be liable for a violation of certain laws, rules, or standards by acting negligently. But a person associated with that firm who directly and substantially contributed to that same violation must have acted at least recklessly to be liable. This inconsistency results in associated persons having less of an incentive to exercise the appropriate level of care in their audit work. Harmonizing these differing liability standards would allow the board to fulfill its congressional mandate more effectively. And this is especially useful at a time when audit deficiencies and an overall drop in audit quality continue to persist. Data provided by the board in its release show that since 2009, in over 2/3 of the cases in which a firm has been sanctioned, no individual was held accountable under the board's contributory liability. In the past 5 years, on average, only 18% of all cases in which a firm has been sanctioned included individuals charged under this rule. This amendment will benefit investors by increasing the likelihood of misconduct being detected and sanctioned. While the Sarbanes-Oxley Act requires the Commission and the board to coordinate their enforcement efforts, their respective mandates are distinct and enforcement resources are finite. The board's amendment will prevent duplication of efforts in cases where the board, under the current outdated rule, might need to refer one piece of a broader case to the Commission to take action as appropriate against a negligent individual. Public company audits can be complex, requiring auditors to make significant judgments about emerging and evolving risks. But this is not a reason to allow individuals to, by definition, act unreasonably in contributing directly and substantially to a firm's violations without ever facing any consequences. Updated liability standards for associated persons will strengthen accountability and prevent negligent behavior. The Commission staff has determined that the PCAOB's amendment to the contributive liability standard is consistent with Title I of the Sarbanes-Oxley Act and associated rules and regulations. Following its own thorough review of the PCAOB's efforts, Commission staff has also determined that the amendment is necessary or appropriate in the public interest or for the protection of investors and is recommending Commission approval. Because the amendment will help deter negligent auditing practices by associated persons, provide for more effective enforcement by both the board and the Commission, and potentially contribute to increasing audit quality, I am pleased to support the staff's recommendation. Thank you.
Thank you, Commissioner Lizarga. Thank you, all of my fellow commissioners. If there's not any additional comments or questions for the staff, I'll ask the commissioners to vote on possible approval of this amendment to the PCAOB Rule 3502 governing contributory liability.
No.
Yes.
No.
Yes.
Yes, the ayes being 3-2, the matter passes and is approved. And with that, we're going to turn to the second of our 3 items. We'll be considering to approve yet another final standard related to an update to general responsibilities of auditors when conducting an audit. I'm pleased to vote in support of approving the final standard because it would modernize, streamline core obligations required of auditors. Now, for the listening public, currently auditors are held to a set of foundational standards such as due professional care, professional skepticism, independence, competence, reasonable assurance, professional judgment. These obligations exist ultimately to protect investors and users of those financial statements. They're kind of the building blocks of independent audit and are central to investors' trust in our markets. I occasionally like to turn to Supreme Court opinions, but here I think one is really worthy to turn to. 40 years ago, the Supreme Court Chief Justice Warren Burger noted the importance of the public's confidence in the independent auditing process. This was in a case called United States versus Arthur Young and Company. That was an auditing firm back then. Chief Justice Berger wrote for the court, it is, quote, not enough that financial statements be accurate. Think about that. Not enough that the financial statements be accurate. The public must also perceive them as being accurate. And then Chief Justice Berger went on and said, quote, public faith in the reliability of a corporation's financial statements depends upon the public perception of the outside auditor as an independent professional, end quote. Well, that's actually the law of the land written by the Chief Justice in a majority opinion. But I agree with the Chief Justice so much. Investors need credible, high-quality information when making investment decisions, and the quality of such information depends not only on that which the companies provide, but the integrity of the auditors doing the auditing. Today's proposed standard would replace 5 interim standards. I'd earlier said that there were 42 that were still interim when I came on board at the SEC. This addresses 5 of those, which were originally developed by the AICPA decades ago and just put in on an interim basis by the board in 2003. Let me just put this in perspective. Some of these standards were the same when I took and later taught undergraduate accounting at the University of Pennsylvania. And I don't mind saying it, that was 45 years ago. That is what we're doing. We're considering some standards. The PCAOB is updating. Not only do they put it in place on an interim basis 21 years ago, but some of these are actually the same standards as when I was back at Penn. Since then, of course, technological advancements have introduced new auditing tools and software. The requirements related to risk assessment and independence have changed, and today's audits are not the paper and pencil audits of 45 or 50 years ago. The profession should have a standard that reflects today's digital reality. So this proposal we're considering today, it's called AS 1000 or Auditing Standard 1000, would modernize, streamline the general principles, responsibility of auditors. Doing so makes it, I think, easier for auditors to understand, apply, fulfill their duties, and it probably makes it easier to teach it back at universities. In addition, the proposed standard would update the auditor's objective to cover both a financial statements audit as well as an audit of internal controls over financial reporting. And this internal controls over financial reporting became even more important, more highlighted after the calamitous results out of Enron and WorldCom 20 plus years ago. I think these are all good things, but in addition, it would explicitly tie the PCAOB's, and SEC independence rules into this as well. So audit engagement partners have this responsibility to act with due professional care, as I mentioned. Importantly, the proposed standard would clarify engagement partners' existing responsibilities. The proposed standard also clarifies the meaning of a term called presents fairly. Now, what does that mean? It just means that today in the standard, it says presents fairly as a reference to preparing the financial statements in accordance with generally accepted accounting principles, or something called GAAP. Well, the revision might sound small, but it would change this to a reference to preparing financial statements in accordance with the applicable financial reporting framework. This change also emphasizes auditors' evaluation of fair presentation, extends beyond technical compliance. So again, I'm glad to support this approval of these updates to the core responsibilities of auditors. I hand it over to our Office of Chief Accountant again. I want to thank all of the divisions again that have worked on this. And you could look at the website, sec.gov. But again, over to you, Chief Accountant Munter.
Thank you, Chair Gensler. Fareeba Nassery, Associate Chief Accountant in the Office of the Chief Accountant, and myself will present the staff's recommendation to approve a proposal by the PCAOB to adopt a new auditing standard on general responsibilities of the auditor in conducting an audit, together with related amendments to certain other PCAOB standards, which I will refer to collectively as AS 1000. AS 1000 reaffirms the general principles and responsibilities of the auditor so that the foundation underlying the board standards continues to be sound and appropriate for performing high-quality audits and continues to protect investors. These general principles and responsibilities include keystone topics such as affirming the auditor's duty to protect investors through the preparation and issuance of informative, accurate, and independent auditor's reports, the exercise of professional care, of due professional care, of professional skepticism, and professional judgment when performing audits, and complying with ethics and independence rules and regulations. The PCAOB's current audit standards on these topics, as the chair mentioned, were adopted from then existing American Institute of Certified Public Accountants, or AICPA standards, by the PCAOB in 2003. And some of those audit standards were issued over 50 years ago, as was highlighted by Chair Gensler. While the principles embodied in those standards continue to be the bedrock of the auditing profession, an update was long overdue to reflect the views of the impartial regulator of the audit profession at the PCAOB and is warranted given the 50-year evolution in the auditing environment. AS 1000 not only modernizes the foundational standards, but through its updates, it refocuses and reorients the auditor's responsibilities on its critical role of public watchdog, a term that was coined in the U.S. versus Arthur Young Supreme Court opinion that the chair referenced a moment ago. AS 1000 critically advances the board's investor protection mandate under Sarbanes-Oxley by, among other things, first, placing fidelity to the investor at the center of the auditor's purpose by explicitly stating that the auditor's fundamental obligation is to investors and not to management of issuers. Second, all too often we hear auditors speak about what they are not required to do or what they are not responsible for, instead of focusing on efforts that will best serve the public trust. And these amendments appropriately anchor an auditor's responsibility in the affirmative in terms of what is required, rather than intermingling those requirements with other discussions on limitations of an audit and limitations on the auditor's responsibility. Third, the amendments reaffirm that auditors must fulfill their professional responsibilities with appropriate rigor and diligence. AS 1000 extends the requirement of due professional care to other areas of audit practice, including public reporting and documentation, and by aligning engagement partner supervisory responsibilities with the principle of due professional care. And finally, these amendments emphasize the existing responsibility that an auditor needs to exercise professional judgment to determine whether the financial statements are not misleading within the context of an applicable financial reporting framework, by clarifying that presents fairly goes beyond mere technical compliance with the accounting standards, as Chair Gensler mentioned a moment ago. Indeed, in SEC Regulation SX Rule 401A, the Commission states that compliance with the applicable financial reporting framework is a minimum requirement to which shall be added such further material information as is necessary to make the required statements, in light of the circumstances under which they are made, not misleading. Accordingly, recognition of this principle in PCAOB auditing standards is long overdue. OCA and other Commission staff have reviewed AS 1000, the comment letters received by the board, as well as those received by the Commission, and other information submitted by the board. And based on this review of the standard, we recommend the Commission approve AS 1000. Again, many members of the commission staff have contributed to reviewing the amendment and preparing this recommendation. I will list all of those in my remarks for the next matter before the commission. And now we'll turn it over to Fariba to provide more detail about AS 1000.
Thank you, Paul, and good morning, Chair Gensler and commissioners. As Paul stated, the current audit standards that address the general principles and responsibilities of the auditor were adopted from the then existing AICPA standards by the PCAOB shortly after its creation in 2003, but their origins are many years older. In March 2023, the board proposed AS 1000 in an effort to modernize these standards. In response, the board received 28 comment letters from stakeholders, all of which were considered by the board and are discussed and addressed in their adopting release. In May 2024, the board unanimously approved AS 1000, and we published a notice to solicit comment on the amendment. We received 12 comment letters in response to our notice, all of which have been considered by commission staff. Given the evolution of the audit environment and advancements in technology, AS 1000 reaffirms and modernizes the general principles and responsibilities of the auditor to ensure that the foundation of auditing is appropriate for performing high-quality audits in the public interest for the protection of investors. As adopted by the PCAOB, AS 1000 enhances the existing general principles and responsibilities of an auditor by, in addition to those discussed by Paul, reaffirming the auditor's fundamental obligation to protect investors through the preparation and issuance of informative, accurate, and independent auditors' reports in accordance with the PCAOB standards, updating the existing objectives of the auditor by incorporating the responsibility of an auditor to conduct an audit of the effectiveness of a company's internal control over financial reporting, or ICFR, when required by Sarbanes-Oxley and Commission rules. This acknowledges that the foundational principles apply equally to audits of ICFR as to financial statement audits and better aligns the objective with board-issued standards. Retaining and clarifying the general principles and responsibilities that are critical for an audit, including reasonable assurance, due professional care, professional skepticism, and professional judgment. Aligning the engagement partner's supervisory responsibilities with due professional care. Retaining the requirement for the auditor to be independent by explicitly referring to both the PCAOB's independence criteria in its rules and standards and the Commission's independence requirement. Defining the auditor's obligations to comply with ethics requirements, obtain and maintain competence, and prepare audit documentation. And finally, removing language that is outdated, inconsistent, and not relevant to audits conducted under the standards of the PCAOB. The related amendments also improve other PCAOB auditing standards that address responsibilities fundamental to the conduct of an audit, including by clarifying the engagement partner's existing due professional care responsibilities in AS 1201, AS 2101, and AS 1215, also known as the supervision of the audit, audit planning, and audit documentation standards, to provide greater specificity concerning their supervision and review obligations under existing auditor requirements. Focusing further still on audit documentation, the amendments also clarify existing audit documentation requirements to identify who on the audit team performed the work, who reviewed the work, and the date of that review, which all should be prior to the report release date. And lastly, accelerating from 45 days to 14 days, the period to assemble a complete and final set of audit documentation for retention, also referred to as the documentation completion date, modernizing this requirement as a result of developments in the performance of audits since the standards were adopted. As we discussed with respect to the contributory liability amendment, the Commission needs to make a determination regarding the application of the amendments to the audits of EGCs. As discussed more fully in the draft Commission order, we believe that applying the amendments to the audits of EGCs is indeed necessary and appropriate in the public interest after considering the protection of investors and whether the action will promote efficiency, competition, and capital formation. Moreover, in general, the alternative of not applying the same standard and related amendments to audits of EGCs and non-EGCs creates the potential for confusion or even potential additional costs to maintain separate methodologies. Overall, the amendments are expected to enhance audit quality and contribute to an increase in the credibility of financial reporting for all issuers, including EGCs, whose financial statements are audited by a registered public accounting firm. Higher audit quality improves efficiency of capital allocation and lower cost of capital and enhanced capital formation with respect to EGCs and other issuers. As expanded upon in the draft order, we have reviewed and considered AS 1000, the information submitted by the PCAOB, and the comment letters received. Based on that review, and as stated by Paul in his remarks, we recommend approval because AS 1000 is consistent with the requirements of Title I of the Sarbanes-Oxley Act and is necessary and appropriate in the public interest or for the protection of investors. Also, as I discussed earlier, we recommend applying AS 1000 to audits of EGCs. If approved by the Commission, the amendments will be effective for audits of financial statements for fiscal years beginning on or after December 15th, 2024, except that for registered public accounting firms that provide audit opinions for 100 or fewer issuers during the calendar year ending December 31st, 2024, the amendment relating to the documentation completion date will not take effect until audits of financial statements for fiscal years beginning on or after December 15th, 2025. In closing, I would like to echo Paul's thanks to our colleagues within the Office of the Chief Accountant throughout this project. I will now turn it back to you, Chair Gensler.
Thank you very much. And over to you, Commissioner Peirce, for questions.
Thank you, Chair Gensler, and thank you to Fariba and Paul. I support this new auditing standard, which, in the words of the PCAOB, reaffirms the general principles and responsibilities of the auditor so that the foundation underlying our standards continues to be sound and appropriate for performing high-quality audits. Undergirding my support is an expectation that the PCAOB will stand ready to provide guidance, answer questions, monitor for issues during implementation, and conduct a post-implementation review. The new standard, by modernizing and consolidating a group of interim standards adopted at the PCAOB's inception, should facilitate compliance and strengthen audit quality. The adopting release is helpful in setting the basic parameters within which auditors operate. It reaffirms that the auditor's fundamental obligation is to protect investors through the preparation and issuance of independent auditors' reports. While this language does not change auditors' obligations, it places appropriate emphasis on the investor. The shortening the time period within which auditors must complete their documentation also should be protective of investors. The PCAOB worked to balance principles-based standards with specificity in response to commenters' questions. Commenters also were generally supportive of AS 1000, but underscored the need for post-implementation review and also for implementation guidance. I do have a number of questions. One commenter opined that, quote, the adoption of AS 1000 is expected to have a profound impact on the auditing profession. Do you agree with that, Paul? And if so, what do you anticipate being the biggest changes resulting from this standard?
Commissioner, I don't know what commenter you're referring to, but I guess the most significant change.
It was a commentator. I'm sorry, it wasn't a commenter who wrote into us. It was a commentator.
Okay. The most significant change is what you touched on, Commissioner, which is the acceleration of the file closure date, which the PCAOB, of course, has given consideration to the time that might be necessary for some firms to update their processes and procedures. And for, frankly, the vast majority of audit firms, that requirement won't take effect until audits for periods beginning after December 15th, 2025 or calendar 26, which means that doesn't take effect until the spring of 2027. With respect to the other matters, as you also touched upon, what the PCAOB is doing is modernizing and updating foundational concepts that are bedrock to the practice of audit. So I guess if I were to have a conversation with such a commentator that thinks that it would have a profound impact on an audit practice, candidly, I would begin the conversation, Commissioner, with wanting to understand why that firm thinks it's compliant with the current standards.
To be clear, it wasn't a firm that made that comment. So I had the same reaction that you did, which is this standard is really underscoring existing obligations. And I agree with you that the time change for the work papers seemed to be the biggest change from my perspective as compared to what is so under the existing rules. The adopting release states that auditors should pay attention to guidance, whether included in an adopting release or staff guidance, but that such guidance is not binding. They're referring there to, the board was referring to PCAOB guidance. Did the PCAOB put all the guidance intended to be authoritative in the standard itself as opposed to in the accompanying release?
Well, the PCAOB provides the authoritative guidance and obviously lots of additional material in its release. I would say that is not at all uncommon if you look at accounting and auditing standards. The FASB, when it issues an ASU, includes basis for conclusions as part of the ASU, which are non-authoritative. The IASB also includes basis for conclusions and sometimes non-authoritative illustrative examples. The International Auditing and Assurance Standards Board provides for application material in addition to the standards itself. So that is not at all uncommon with respect to accounting and auditing standards, Commissioner.
Okay, but the auditors can find what is authoritative in the standard itself. They don't have to, the other guidance can be helpful, but the authoritative material is in the standards.
That's correct.
Okay. The order, our order states, for audits of stub periods, we believe the effective date of the document completion requirement is clear. Nevertheless, we encourage the PCAOB staff to consider the need to provide additional guidance which could be useful to firms. What is the effective date of the document completion requirement for stub periods?
Well, the effective date is anchored in when the financial statement period begins, whether it is a 12-month period or some different period that is the financial statement period. And it's for audits of engagements for periods beginning after December 15th, either 24 or 25, depending upon how many audits the firm has issued in calendar 2024. So that requirement is not at all different. And the document completion date is anchored in the number of days after the report release date. Again, whether or not the period being audited is a 12-month period or some different time period.
Okay, thank you. The standard requires auditors to critically assess audit evidence and other information that is obtained to comply with PCAOB standards and rules. AS 1105 governs the critical assessment of audit evidence, but what standard applies to the critical assessment of other information that is obtained to comply with PCAOB standards and rules?
Well, it depends on the source of the information. When we're talking about audit evidence, in that circumstance, the auditor is evaluating information either received from the entity under audit or perhaps from third parties, and therefore is information that's not within the direct control of auditors. And as a consequence, as you observe, Commissioner, there is guidance in the PCAOB audit standards on how an auditor should evaluate the reliability, the quality of the audit evidence to determine that the auditor has sufficient appropriate audit evidence. When you're talking about information that is the product of the firm's own work, that's not really an analogous fact pattern because the firm does have direct control over that information.
Okay, well, it seems that this might be an area where more guidance is needed from the PCAOB. So it's something that the board should think about. This standard, given that it's fundamental, is applicable to audits of broker dealers, but the adopting release really barely mentions broker dealers. did the PCAOB adequately consider any unique issues related to broker-dealer audits?
The PCAOB did consider the application of this to all audits, whether it's for registrants or audits of broker dealers. One of the points that Fariba made in her remarks is that because these are foundational principles that underlie audits, it would be extremely difficult to develop an audit practice where you are applying different foundational principles for different audits.
Yeah, and I think when she made that comment, she was referring to EGCs versus non-EGCs, and certainly understand that point. And I agree with you that given that these rules are fundamental, they probably do apply pretty broadly, no matter whether you're auditing a broker-dealer or an issuer. But I guess the question is, for me, it would be helpful. Maybe it's not a question, but it's a comment. It would be helpful if the adopting releases had more evidence that the PCAOB was thinking specifically, is there anything that's different when it comes to broker-dealers? And I just don't see a lot of discussion of broker-dealer audits in the PCAOB releases. At the open meeting adopting this standard, one of the PCAOB economists noted the assistance of the SEC in preparing the economic analysis. What was our contribution to that analysis? And what does the statute require of us in the PCAOB when it comes to performing an economic analysis? And Paul, you're free to hand that off to either DERA or GC or a combination of the two.
I'll take a first stab, Commissioner. We certainly engage with the PCAOB as support of you and fellow commissioners' oversight of the PCAOB and provide technical support. And then obviously we review the proposals and adopting releases, as well as the comment file that comes into the PCAOB, as well as the comment file that comes into us as part of our efforts to support your oversight of the PCAOB.
And Megan, I don't know if you or someone from GC wants to weigh in on economic analysis and what's required.
Thank you, Commissioner Peirce. I can weigh in on the economic analysis questions, and I'll just take those in turn. SOX does not require the PCAOB to conduct an economic analysis, but as a matter of policy and as reflected in the releases, the PCAOB does undertake an economic analysis to enhance its policy-making process and inform its decision-making. And then as part of its review of a proposed rule change, the Commission assesses that economic analysis that's included in the PCAOB's proposed rule filing. And to the extent any commenters have weighed in on the rule's economic effects, the Commission would consider those comments as well.
Okay, thanks. I mean, I can't imagine why any regulator, the PCAOB or the SEC, would want to move forward with something if there wasn't a pretty clear understanding of what the problem is that's being solved and whether the solution being chosen is the best alternative out there, and some thought around what unintended consequences might be of the standard or the rule. I think we can do more work on the economic analysis in connection with PCAOB rulemaking and standard setting. I don't have any additional questions. Thank you.
Thank you, Commissioner Peirce. Commissioner Crenshaw.
Thank you. AS 1000 is an important step forward for investors and all users of financial statements. The standard reaffirms the auditor's duty to protect investors, to act with due professional care, skepticism, and judgment, and to perform the audit to obtain reasonable assurance that the financial statements and the internal controls over financial reporting are sound. A high-quality audit is the foundation upon which investor trust and flows of capital are built. And the requirements of AS 1000 form the building blocks of that foundation. The U.S. capital markets are often the best option for everyday investors seeking a place for their own hard-earned dollars, to put into a down payment for a home, a college tuition, or secure a retirement. But the system that makes up our markets is inherently complex. Investors must navigate an intricate web of actors with varying incentives, layers of specialization, and a host of technical functions. When evaluating issuances of securities and the financial statements that underlie their value, investors rely upon specialists like auditors. In order to ensure that their trust in and expectation of auditors and actors like them is not misplaced, it is necessary to have a meaningful baseline of professional standards that carry consequences for failing to meet them. These are the standards that AS 1000 requires. Further, in proposing and adopting AS 1000, the PCAOB is exercising its crucial role as an independent regulator of the auditing profession. As AS 1000 replaces a group of standards that were adopted wholesale from standards written by the profession itself decades ago through the American Institute of Certified Public Accountants, or the AICPA, which you've already heard about. In that initial release, the PCAOB noted that the AICPA standards were adopted on a transitional basis. To ensure continuity, the PCAOB would establish, quote, a schedule and procedure for the review of all interim professional auditing standards, close quote, to determine whether those interim standards would be appropriate as permanent PCAOB standards. That was, as the chair noted, over 21 years ago. Until recently, the vast majority of relevant interim standards remained in substantially the same form in which they were adopted, and many were decades old. I do applaud this board for its leadership in fulfilling its role as an independent auditing standard setter and regulator of the audit profession. The PCAOB is living up to its obligations to protect investors and further the public interest in the preparation of informative, accurate, and independent audit reports, so that there is a foundation upon which investor confidence and trust can be anchored. Thank you again to the hardworking staff in the Office of the Chief Accountant at the SEC, as well as Paul, the Director of the Office of the Chief Accountant, as well as members of the PCAOB board and its staff. Thank you, and I support today's standard.
Thanks, Commissioner Crenshaw. Commissioner Ueda.
Thank you, Chair Gensler, and thank you to the staff for your presentation. The second item on today's agenda is a new auditing standard on the general responsibilities of an auditor in conducting an audit. AS 1000 is intended to set the foundational standards that apply to audits, including reasonable assurance, due professional care, professional skepticism, independence, competence, and professional judgment. Given that these foundational standards have been adopted on an interim basis shortly after the PCAOB's creation over 2 decades ago, a set of final standards is long overdue. Commentators raised several concerns about the proposal for AS 1000, including whether the new standard imposed a new legal duty on auditors, and whether statements in the proposal relating to the auditor's judgment concerning fair presentation expanded an auditor's responsibilities or created conflicts. The PCAOB appears to have addressed these concerns, as noted by some board members when approving the standard, and by market participants that submitted letters to the Commission in support of the standard. Because of the PCAOB's efforts to address commenters' concerns, as well as market participants' general approval for AS 1000, I support the new standard. I thank the PCAOB members and staff, and the Commission staff as well, especially those from the Office of the General Counsel and the Office of the Chief Accountant in putting together this item. Couple of questions and observations. One of the things I thought was very interesting here was that PCAOB did a staff analysis that estimated that exchange-listed non-emerging growth companies, or at least when compared to exchange-listed non-EGCs, exchange-listed EGCs are approximately 2.6 times more likely to be audited by a non-affiliated firm. Can you comment briefly about sort of how we think about the differences, and or at least what we're trying to do to make sure that rules adopted don't disproportionately favor or disfavor a non-affiliated auditing firm as opposed to a global network auditing firm?
Certainly, Commissioner. I think there's basically 2 aspects here. One is the modernization and updating of the core or foundational principles to the audit. And in that respect, what the PCAOB is actually doing is making it easier for an audit firm or an auditor to understand the responsibilities of the auditor. The other, which we touched on earlier, of course, is accelerating the file closure date, which, as you know from the adopting release, the PCAOB has given consideration to the fact that some audit firms might need a longer period of time in order to adjust their systems and processes to allow for an accelerated file closure. And frankly, for the vast majority of firms, those that do 100 or fewer audits, which is, the vast majority of the registered firms under the PCAOB regime, they have until audits for periods beginning after December 15th, 2025, or calendar 26 audits to implement that. I think it's, in thinking about that, very important to note that auditors are required to complete all of their audit procedures by the report release date. And the period after the report release date to the file closure date is not for conducting audit procedures, but rather just to complete the ministerial task of documenting the procedures that were done. And so I think the PCAOB is being responsive to the fact that some firms may need a bit longer time to accelerate their processes by building in a later effective date for the vast majority of firms for that particular requirement.
Well, thank you for that. Yeah, no, I think it's important as part of our oversight, as part of this order, we specifically have to make findings on efficiency, capital formation, and competition. And so that's part of our order. Competition, you can think in a number of different ways. But in this respect, I do think we don't want to see an uncompetitive field where only, for instance, the global network firms can undertake these because we create such high barriers to entry and high expense that no one else can do that. Now, one thing that the board does lay out on this whole EGC versus non-EGC differential is that the board, it seems to me they more speculate that EGC audits may be less complex, which can potentially facilitate a more a faster assembly of all the final work papers. And that very well may be true. What would be helpful and if you can convey to the PCAOB is that there's this technique called sampling, and they could sample a number of EGC firms and their audits and actually see if that's true or not. Because I would prefer that when we do economic analysis, it be data driven, and at least it seems that I would actually think that they can make a big contributor in this respect to the overall capital formation discussion we're having. Is the rule book creating, at least at the margins, disincentives to go public? We have this debate all the time. Stay private, continue to raise money under Reg D or one of the other exemptions, or go public, and there are lots of pros and cons with each. And just getting at least some factual information. So if you could convey that, that would be helpful. And the other part is at least the PCAOB seems to make some explanations about reliability of the EGC's financial statements may result in investors commanding a larger risk premium that could impede the efficient allocation of capital or increase the cost of capital. And this is something that I know they've got various advisory groups for to encourage the PCAOB to do further. If you can convey that for me, because I think it's important. What exactly are the investors looking at? Especially, we've got all sorts of different types of investors. Some that are asset managers who run indexes, for instance. They really don't look at the financial statements because their main aim is to match the index. We have a lot of hedge funds and others who are basically are in and out of a security very, very quickly based on aberrational market prices. They're not looking at the financial statements, but then there are very important fundamental investors who I think we think of as the traditional users of this. But I would also add, they should be talking to, well, what do the short sellers look for in financial reporting? What do they think, and what do they look at? What do they rely on in the audits, because I think they contribute as well to price discovery. So just again, if you can sort of convey that and think about those things as we oversee their efforts. As Chair Gensler said, these are only 5 of the interim standards. And so it sounds like they have quite a few more to do going forward. And hopefully this is not like some of the so-called temporary buildings that we see here in Washington, D.C. for government office space that somehow end up lasting for a half century or more. So good luck with that. No further questions.
Thank you, Commissioner Ueda. No, I hope that it doesn't last 50 years. Commissioner Lizarga.
Thank you, Chair Gensler. Today, the Commission considers a new PCAOB auditing standard to consolidate and replace interim foundational standards first put into place in 2003, following the enactment of the Sarbanes-Oxley Act. These foundational standards, some of them initially issued by the AICPA over 5 decades ago, as has been said, address the general principles and responsibilities of the auditor in conducting an audit. These include those relating to due professional care, professional skepticism, competence, and professional judgment. The new standard does not create new obligations for auditors. However, the auditing environment has evolved significantly since the board first adopted interim standards in 2003. In the face of rapid change, investors are better protected with updated and modernized standards that can yield more informative, accurate, and independent financial reporting. The board's new standard clarifies the auditor's responsibility to evaluate whether the financial statements are presented fairly in the context of the applicable financial reporting framework, in a manner that is not misleading to investors. It will also require auditors to assemble a complete and final set of audit documentation in 14 days, instead of the current 45, to reflect the electronic-based environment auditors now operate in. The new standard clarifies that auditors must exercise professional skepticism and judgment throughout the audit process, consistent with longstanding investor expectations about the fundamental responsibilities of auditors. The amendments should benefit investors by making auditors' foundational obligations clearer and more user-friendly. Firms will be in a better position to train new auditors. Investors and audit committees can better understand what auditor responsibilities are, ultimately improving the quality of financial reporting. Commission staff has determined that the board's amendments are consistent with Title I of the Sarbanes-Oxley Act and associated rules and regulations. Following its own thorough review of the board's efforts and extensive engagement with the board throughout the process, Commission staff has also determined that the amendment is necessary or appropriate in the public interest or for the protection of investors. The staff is therefore recommending Commission approval. I am pleased to support. Thank you.
Thank you, Commissioner Lizarga. Thank you, all of my fellow commissioners. If there's not additional comments or questions, with that, we'll call the question of how the commissioners vote to approve AS 1000, general responsibilities of the auditor in conducting an audit.
Yes.
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 Yes, the votes being unanimous, the PCAOB standard AS 1000 is approved. I had checked with the commissioners, so we're just going to try to do this. The third of 3 data and technology amendments and power through. What we have is considering to approve final amendments regarding the use of technology-assisted data analysis in audit procedures. I'm pleased to support approval of these amendments because they will provide auditors with modernized guidance regarding the use of such tools. I have a longer statement I'll put on the website, but I think that the existing audit standards were written in an earlier technological era. They were updated in 2010, but even in 14 years, a lot does change. And with the PCAOB revisiting the standards, how to address auditors, in essence, assessing the quantity and quality of audit evidence when using technology-assisted analysis. Again, I'll have a longer statement for the record, but I think with the greater use of auditors of data analysis tools, today's amendments could help the profession in using such tool, and I thank the PCAOB taking this effort up to keep pace with technology in the accounting field. Again, I'll turn over to the chief accountant, Paul Munter, and I think Keith Hooper is going to join to tell us about this standard.
Thank you, Chair Gensler. And as you mentioned, Keith Hooper, a professional accounting fellow in my office, and I will now present the staff's recommendations to approve the proposal by the PCAOB to adopt amendments to AS 1105, audit evidence, and AS 2301, the auditor's responses to the risk of material misstatement, addressing aspects of audit procedures that involve technology-assisted analysis of information in electronic form. Auditors are expanding their use of technology-assisted analysis, often referred to in practice as data analysis or data analytics. They use these tools in many ways, including to examine the correlation between different types of transactions or account balances, compare company information to auditor-developed expectation or third-party information, or to recalculate company information. While existing PCAOB standards specify fundamental auditor responsibilities, including response to risk, many of the standards were written prior to the emergence of many of the technologies commonly used in audits today, and auditors may currently need to analogize those standards to determine an appropriate response when using these analytical tools, and there may be a resulting confusion, diversity in practice, or even reluctance to adopt the new technologies. The challenges faced by auditors with respect to their rapidly evolving use of technology-based analytical tools are not unique, but are the universal challenges faced by all adopters of these technologies. Some of the challenges that are addressed by the amendments include assessing the reliability of external information, determining the level of reliance that can be placed on the output of a procedure, and investigating items that are not in line with auditors' expectations. Keith will discuss these challenges in more detail in just a moment, but the bottom line is that if not properly designed and executed, audit procedures that involve technology-assisted analysis may not provide sufficient appropriate audit evidence as required by the applicable audit standards. In developing these amendments, the board took into account input from its ongoing research project, from working groups, internal and external outreach, inspection findings, enforcement actions, feedback from commenters, and engagement with its advisory groups. The amendments are narrow in scope and are principles-based and are not intended to address all uses of technology. Further, to avoid the new standards becoming rapidly outdated, the amendments do not require the use of specific types of technology. These amendments represent an important foundational step of the board addressing these rapidly and ever-evolving challenges and opportunities. The amendments should reduce the risk that an auditor who uses technology-assisted analysis in an audit may not obtain sufficient appropriate audit evidence to support the opinion. The clarity the amendments provide should also address the reluctance of some auditors to use technology-assisted analysis under existing PCAOB standards. Therefore, we recommend that the Commission approve the amendments to AS 1105 and AS 2301. In just a moment, I'll hand over to Keith to provide more information on the amendment. But before doing so, I do want to recognize a number of people who have made significant contributions to the staff's recommendations for the Commission on all three of these projects. From the Office of the General Counsel, Megan Barbero, Brian Morris, Peggy Kim, Eduardo Alaman, and Hillary Holman. From the Division of Economic and Risk Analysis, Jessica Wachter, Olivia Richard, Lauren Moore, Charles Woodworth, Lyndon Orton, Rebecca Orban, and Albert Sheen. And in my office, the Office of Chief Accountant, Natasha Guinan, Anita Dowd, Shaz Niazi, Greg Hilson, Michael Wheatown, Fariba Nasri, Keith Hooper, Mark Jacoby, Taylor Pross, John Riggs, and Dana Cruto. And of course, a number of others that I don't have time to name in divisions of enforcement, investment management, corporation finance, trading and market, as well as the Office of Secretary. I would also, of course, like to thank the board and the staff of the PCAOB as well. And now let me hand it over to Keith to provide more detail on these amendments.
Thank you, Paul, and thank you, Chair Gensler and Commissioners. Given the advancements in technology, many auditors have incorporated technology-assisted analysis into their audits to enhance their procedures. As Paul indicated, the amendments that the Commission is considering today are designed to further clarify and specify certain existing auditor responsibilities as they relate to this technology. They are intended to be adaptable to the ever-evolving nature of the use of technology in the audit. In June of 2023, the board issued its proposal relating to these amendments. In response, they received 21 comment letters from stakeholders, all of which were considered by the board and are addressed in their adopting release. In June of 2024, the board unanimously approved the amendments, and we published a related notice to solicit comments. We received 7 comment letters in response to our notice, all of which have been considered by Commission staff. And now I will provide you with more detail on the matters that Paul highlighted that are addressed by the amendments, and I will begin with assessing the reliability of external information. While historically third-party data was commonly considered by auditors to be reliable, the expansion of technology has the potential to increase risks relating to the modification of such third-party data. So this can be the case, for example, if a third party provides the company data through an automated feed, and then the company under audit maintains that data in their records. So to address these considerations, the amendments include a new paragraph, AS 1105 paragraph 10 cap A. This addresses auditors' assessment of reliability when third-party information is provided to them by the company being audited. Subparagraph A of the new paragraph directs the auditor to understand the source of the information and how it was received, maintained, and if applicable, processed by the company. This new requirement is a critical step to ensure that the auditor has an appropriate understanding of the risks that the company's process introduces to the reliability of third-party information. And I will note that the existing and unamended paragraph 9 of AS 1105 frames the auditor's responsibility in the context of their risk assessment as it relates to document authentication. So simply stated, unless the auditor becomes aware of conditions that indicate a document may not be authentic or that its terms have been modified, the scope of the auditor's procedures need not extend to validating the authenticity of each document that they obtain. Next, subparagraph B of the new paragraph 10 cap A directs the auditor based on the risk assessment that I just discussed to perform procedures to validate the reliability of that evidence. The standard allows the auditor to either test the company's controls or to design their own testing of the information, and it does not prescribe the nature, timing, or extent of those procedures. Let me move next to determining the level of reliance that can be placed on the output of a procedure. An auditor's categorization of a procedure informs the requirements around its performance and informs the auditor's assessment of the sufficiency of the evidence that it provides. To clarify this categorization, the amendments do 2 things. First, they describe a test of details. Historically, the concept of a test of details, while not explicitly defined in the standards, has been widely understood by auditors. These traditionally included procedures like comparing a sample of the company's recorded expenses to supporting third-party documentation. However, changes to audit procedures have blurred the lines between types of procedures and have increased the need for a clear description that can be consistently applied across all audits, which the amendments do provide. Second, the amendments state that the auditor determines the type of the procedure based on its purpose. Further, they state that procedures may be used for more than one purpose as long as each purpose's objective is achieved. And while existing PCAOB standards did not preclude auditors from using procedures for more than one purpose, this important affirmation clarifies for auditors that the use of a procedure for more than one purpose is acceptable when properly performed. And moving last to items that are not in line with auditors' expectations. For example, a revenue entry that was expected to match to a cash receipt but did not. Technological advances have expanded the scope of what some auditors test, while also potentially expanding the population of items not meeting the auditor's expectation, which may be comprised of many small items. The new requirements are principles-based, integrate with the board's other risk assessment standards, provide auditors with the flexibility to design responses that are appropriate for their circumstances, all while ensuring that the risks of material misstatement are sufficiently addressed and that indicators of a misstatement or control deficiency are appropriately evaluated. As mentioned with respect to other amendments today, the Commission needs to make a determination regarding the application of these amendments to the audits of EGCs. As discussed more fully in the draft Commission order, we believe that applying the amendments to the audits of EGCs is indeed necessary and appropriate in the public interest after considering the protection of investors and whether the action will promote efficiency, competition, and capital formation. The amendments may promote higher audit quality for EGC audits that are employing technology-assisted analysis and thus a higher reliability of financial reporting for affected EGCs. This would in turn enhance investor protection and lead to an improved efficiency of capital allocation and enhanced capital formation with respect to EGCs. As also expanded on in the draft order, we have reviewed and considered the amendments, the information submitted by the PCAOB, and the comment letters that we received. Based on that review, and as stated by Paul in his remarks, we recommend approval because the amendments are consistent with the requirements of Title I of the Sarbanes-Oxley Act and are necessary and appropriate in the public interest or for the protection of investors. Also, as I just discussed, we recommend applying the amendments to the audits of EGCs. If approved by the Commission, the amendments will be effective for audits of financial statements for fiscal years beginning on or after December 15th, 2025. And in closing, I would like to echo the thanks that were already given for all of my colleagues' support throughout this project, and I will now turn it back to you, Chair Gensler.
Thanks, Keith. Thanks, Paul. Over to you, Commissioner Peirce.
Thanks, Chair Gensler, and thanks to Keith and Paul. I support, albeit with reservations, today's amendments to the PCAOB's standards on audit evidence and the auditor's responses to the risks of material misstatement. These amendments should help to guide auditors as they increase their use of technology-assisted analysis of information in electronic form. They should help to alleviate the uncertainty that has led to different practices across firms and has kept some firms from using data analytics. The standard is a good start, and I look forward to the PCAOB's continuing efforts to provide regulatory clarity around how auditors can use and respond to their clients' use of new technologies, including artificial intelligence and blockchain. While these amendments do provide clarity about the use of technology, the associated burden on auditors and their clients is a bit unclear. I think that this standard could be interpreted in a very expansive way. The ambiguity around the cost of these amendments flows from how the standard was drafted, coupled with questions about how it will be implemented. Our approval order addresses some of the concerns raised by commenters and encourages the PCAOB to provide further implementation guidance affirming the acceptability of a risk-based approach. And Keith, I thought you did a nice job in underscoring that a risk-based approach is what we expect. I do have some questions. First, have you discussed, and this is probably for Paul, have you discussed with the PCAOB its plans with respect to developing implementation guidance, working with firms on implementation, setting up a mechanism for consulting on implementation questions, monitoring implementation, considering how this standard interacts with other forthcoming standards, and conducting a retrospective assessment of the costs and benefits of these changes?
Thank you, Commissioner. The answer is yes, we have discussed that with the staff at the PCAOB as well as with board members. The PCAOB, on the last point, as you know, regularly conducts a post-implementation review of standards after a period of time, which it certainly is planning to do here. It has a hotline function set up that facilitates dialogue between individual audit firms or auditors and the PCAOB staff, and the PCAOB staff is certainly considering on an ongoing basis whether there's a need to provide any additional guidance in the application of the standard.
Okay, great. Thank you. The final amendments require auditors, among other things, to evaluate whether external information provided by the company in electronic form and used as audit evidence is reliable by testing the information to determine whether it has been modified by the company and evaluating the effect of those modifications or testing controls over receiving, maintaining, and processing the information, including where applicable information technology general controls and automated application controls. And it explains that such information includes cash receipts, shipping documents, and purchase orders. This language sounds pretty expansive. And again, I think Keith did a good job in putting that in context. But I think commenters in our process expressed a concern about whether these amendments are truly risk-based. So if I could just get your quick reaction on whether you on some of their concerns. So I'm assuming that the auditor doesn't, in all circumstances and without regard to the auditor's assessment of risk, have to perform specific procedures to determine whether or not any intentional or unintentional modifications have been made to information a company receives from external sources and provides to the auditor in electronic form.
Yeah, thank you, Commissioner. And I think this is something that we see sometimes in application of audit standards and accounting standards where some stakeholders might have a tendency to read a particular sentence or even a particular paragraph in isolation or in a vacuum. And that's not the way that audit standards are intended to be read. They have to be read in context. And specifically with respect to PCAOB standards, they are framed in a risk-based methodology that the audit process begins with an assessment of where there are risk and material misstatements. And in fact, that is an ongoing part of the audit to continually evaluate risk and where there are risk and material misstatements. As Keith described, we have draft language in the order before you that would speak to that. Certainly the PCAOB's release has language that speaks to that. And as I mentioned just a moment ago, the PCAOB staff stands ready to provide additional guidance if that would be helpful.
Okay, great. Does an auditor have to look at the non-electronic source documents if there's no risk-based reason to think that's necessary?
It would be grounded in the risk assessment, and if the auditor has appropriately concluded that there is not a risk of material misstatement related to that, then they would not need to do that.
What does an auditor do if no hard copy exists because a purchase order was sent to the company in the form of a PDF attachment in an email or was submitted through an electronic portal, or the hard copies themselves were digitized and then destroyed? Does the auditor have to test each piece of information received in electronic form by going back to the original copy?
Well, to begin with, Commissioner, the PCAOB is not defining what a source document is, so it would depend on the fact pattern. It is entirely possible in today's technological environment that source document could be entirely electronic, including potentially from direct feeds from outside parties. So the auditor certainly need to understand what the source of the information is, what risks there are, particularly regarding potential modification of the information in determining what procedures would be appropriate.
Okay, well, so you raised the modification point, and an auditor can test the controls, but the release states that controls over processing the information would include internal controls over any modifications made by the company to the information. Is there any significance to that inclusion of any in the language there?
No, there's not any particular significance to that, other than to say that when we're looking at the effectiveness of internal controls, circumstances where information could be modified is a real challenge to effectiveness of internal controls. And since this is speaking about data that may in fact be in electronic or digital form, there may be a potential risk with respect to modification. So it is reminding auditors to understand that risk in their risk assessment process.
But the company may not have identified a risk of material misstatement that is related to the risk of modification of electronic information. And so they might not have internal controls over that at all. And that's not a problem, right? That's not something that the auditor has to go in and demand that they put in place.
Well, the auditor is not demanding that the company put in controls in place. That being said, in the conduct of the audit, and if it's an integrated audit, the auditor is going to be expressing an opinion on the effectiveness of internal controls over financial reporting. And in a financial statement audit, they're going to be evaluating to what degree can they rely on the internal controls. And in doing that, the auditor may identify where there are missing controls. And that could certainly impact either the auditor's opinion on the effectiveness of internal controls or the degree to which the auditor believes that the controls can be relied upon for the financial statement audit.
No, sure, I understand that, but I think you might have a situation where a company does not identify the risk of modification as being a risk of material misstatement of the financial statements, in which case there wouldn't be a control and that would be fine.
It would depend on the fact pattern. The auditor is going to make an independent assessment of that.
Yeah, I mean, so again, I think there's some areas where this is one of the reasons I have reservations around the standard, because I just don't know what this is going to turn into. And I took a lot of comfort in what you were saying before, which is that this is all risk-based and that this is not an attempt to create a whole new set of controls for companies. This is really tied to a risk-based assessment. And I think we have to underscore that as much as we can. In setting the effective date for this standard, did the PCAOB take into account work that auditors will need to do to incorporate elements of other standards that were recently adopted or proposed? For example, one commenter noted that the PCAOB's proposed amendments to AS 2301, the auditor's responses to the risks of material misstatement, and specifically new paragraph 40A, which are part of the PCAOB's proposal to replace the existing AS 2305, could create significant implementation challenges for both issuers and auditors by broadening the scope of evidence subject to AS 1105, paragraph 10A. Has the PCAOB thought about how these standards are all interacting with each other?
The PCAOB does think about how the standards interact with each other. And frankly, audit standards by their very nature are going to be interacting with one another. I do think the concerns that were expressed in that particular comment that you're referring to is again grounded in the misreading of paragraph 10 capital A and not framing it in terms of a risk assessment framework. Additionally, I think there's another important aspect, which is that the proposals that the Commission is considering here do not require the use of technology. They permit the use of technology by audit firms and address some of the confusion and concerns that auditors have expressed about the current standards. And I think, at least from our anecdotal engagement with audit firms of varying sizes, and from the input the PCAOB has received, that in fact, a lot of audit firms are very much looking forward to these amendments being approved.
No, and that's why I'm supportive of the amendments. I think the goal is to give people the clarity they need so that they feel they can use technology-assisted analysis. And the goal ultimately is to get better audits because people can use technologies that enable machines to do what machines do best and humans to do what humans do best, and apply judgment and allow technology to take care of some of the more mundane tasks. So I think that's all positive. I don't want an interpretation of this standard to be such that people don't use technology because they're scared to use it because it will implicate all of these problems. And so that's why I'm asking all these questions around, really underscoring that this is risk-based, that this is not intended to be a whole new set of work for auditors and companies. And again, I think that's also reflected in the fact that there's not a huge implementation period. And if this really did require a wholesale redesign of what auditors and companies are doing, the PCAOB would have had to afford more time to implement it. Do you agree with that?
I think we're in complete agreement, Commissioner.
Terrific. I don't have any additional questions. Thanks so much.
How interesting when Mr. Munter and Commissioner Peirce are in that much agreement. Commissioner Crenshaw.
Thank you. Technology is everywhere. As I was driving last week, I remembered how long car trips used to require paper maps with highlighted routes, ones that didn't tell you exactly where you made a wrong turn or how to fix it or where the traffic jam is. And likewise, when I was in school, research that used to take hours at the library across multiple media, including sitting at microfiche readers and scrolling through old clips, can now be done in a matter of minutes. Indeed, technological innovation has so fundamentally changed how we operate in the course of our lifetime that it feels like we should add it to the list of death and taxes as among life's few certainties. And while technology may make the performance of our responsibilities easier and more efficient, we should not allow it to erode our commitment to the fundamental principles that underlie our auditing framework. Our third matter today upholds this precept. The requirement that auditors must plan and perform audit procedures to obtain sufficient appropriate evidence to support their opinion on a company's financial statements remains unchanged and holds true whether technology-assisted analysis is used or not. Today's amendments advance that requirement by providing clarity on how to obtain relevant and reliable audit evidence if technology-assisted analysis is used. I commend the staff at the PCAOB for taking the time to study the increased use of technology by both auditors and companies, and then crafting amendments that seek to advance high-quality audits and investor protection. The PCAOB staff's work provides yet another example of how regulatory frameworks can complement the increased use of helpful technologies. I look forward to seeing how innovations in the audit profession will continue to grow and improve, to both serve investors and advance the public interest by promoting high quality and accurate financial statements. Relatedly, the ability to attract and retain young professionals is crucial to the future of the audit profession. Incorporating the use of analytical tools can further those goals so that professionals are not stuck using outmoded methodologies or bogged down in unnecessary time-consuming processes. I hope that the amendments also facilitate progress on this important front. Thank you again to the board members and the staff of the PCAOB and the staff within the Office of the Chief Accountant and all others at the SEC who contributed to today's meeting and the matters we've considered. Thank you.
Thank you, Commissioner Crenshaw. Commissioner Ueda.
Well, thank you, Chair Gensler. And like you, I will put up a longer statement on the website. So updating standards to keep pace with rapidly evolving uses of technology is both necessary and challenging. The types of technology or technology-assisted analysis meant to be captured by a standard today could easily become obsolete next year. Accordingly, a principles-based rather than prescriptive approach to standard setting can be more ideal to ensure that the standards continue to be effective and avoid obsolescence. However, some market participants noted in their comments to the Commission that the final standard to evaluating the reliability of external information provided in electronic form might require a very prescriptive approach. Evaluating whether a PCAOB standard clearly communicates to market participants their obligations is part of the Commission's oversight responsibility when deciding whether to approve a standard. Based on the language contained in the adopting release for the amendments, the Commission does not believe that the PCAOB intended for a prescriptive approach to testing external information provided in electronic form. However, given the commoners' concerns, the Commission encourages the PCAOB to provide implementation guidance on this issue. In light of the Commission's acknowledgement of commoners' concerns and its call for implementation guidance, I support the amendments related to standards involving technology-assisted analysis. I look forward to seeing the PCAOB's guidance. While today's amendments were intended to only address one aspect of the auditor's use of technology, several commenters called for the board to undertake a broader review of how technology, including artificial intelligence, affects audits. PCAOB has created a Technology Innovation Alliance working group to evaluate the use of emerging technologies in the audit space. I think this is a good development and I look forward to seeing future recommendations from this group. So thank you to the PCAOB members and the PCAOB staff, as well as the commission staff, especially those from the Office of the Chief Accountant and the Office of the General Counsel, for your work on this item. One follow-up to the Chief Accountant off of Commissioner Peirce's one of her questions about multiple PCAOB standards being implemented at the same time. Is there any effort at all to think about how various standards going from the I think it's the IAASB, FASB, the IFRS board, as well as the SEC, such as for instance, our climate change disclosure rule had an SX component, all that affects the financial statements and how they're audited. We in the first in the first item, we talked about sort of acting reasonably in terms of negligence. Is anyone sitting a bit? I guess I'll refer back to one of Chair Gensler's office hours clips about needing air traffic controllers to line everything up. Is anybody sort of being the air traffic controller here to say, okay, FASB's got this going on, PCAOB has this, the IAASB has this going on, SEC has this, to sort of think through about the impacts, even though they're coming from different regulatory bodies, they're still going to affect the same set of participants.
Yeah, thank you, Commissioner. And the answer is yes. We spend a lot of time thinking about that. We engage, of course, bilaterally with the PCAOB. We engage bilaterally with the FASB. We engage bilaterally with the IASB, the IAASB, IASBA, but also we bring those parties together periodically as well. So we have regular touch points that involve ourselves, FASB, PCAOB, for example, so that each of the boards can be informed by what is going on their respective plates and potential time horizons that those projects might take to complete.
Well, good. I'm glad to hear that, because I think it really is important. I don't think the model we want to use is the snake swallowing the rabbit whole. If we can take all of these regulatory initiatives in bits and pieces, I think we'll find far more effective implementation. So I appreciate your comments on that. No further questions for me.
Thank you, Commissioner Lizarga.
Thank you, Chair Gensler, and also to my fellow commissioners for your thoughtful comments and questions today, and to the staff of both the Commission and the PCAOB and the PCAOB members as well for all of their work on these important standards. In recent years, auditors have expanded their use of data analytics. This trend has been driven both by advances in data analysis tools and increased access by auditors to large volumes of company and third-party generated data. Where existing auditing standards designed for another era fall short of their potential to help auditors improve audit quality, it makes sense to adapt them to current realities. Audit procedures that rely on data analytics but that are not appropriately designed or executed may not yield the audit evidence required by current auditing standards. The board proposed updates will assist auditors in better analyzing information in electronic form with technology-based tools. The amendments are designed to reduce the likelihood that an auditor will issue a report without obtaining sufficient audit evidence that provides a reasonable basis for its audit opinion. The board has noted that the amendments will help auditors design and perform more effective audit procedures, leading to higher audit quality and benefiting investors. The updated audit standards could also result in more efficient audits and lower audit fees. And the clarity and regulatory certainty they offer could encourage auditors to implement new technologies. As with the previous two standards, the Commission staff has determined that the board's amendments are consistent with Title I of the Sarbanes-Oxley Act and associated rules and regulations. Following its own thorough review of the board's efforts and extensive engagement with the board throughout the process, Commission staff has also determined that the amendments are necessary or appropriate in the public interest or for the protection of investors. The staff is therefore recommending Commission approval. I am pleased to find myself in agreement with the staff recommendation and pleased to support these sensible amendments that we will yield principles-based standards designed to be adaptable to future change in technology and that improve the reliability of financial reporting. Thank you.
Thank you so much. If there's not any further questions or comments, we'll turn to vote on approving the amendments related to this aspect of technology, designing and performing audits procedures involving technology-assisted analysis of information in electronic form. All right, a mouthful, but we discussed it. How do my fellow commissioners vote?
Yes.
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 Yes, the vote being unanimous, the amendments are approved. And with that, this concludes the business of our today's agenda, and the meeting is adjourned.